All right, I've got a number of motions filed on behalf of Mr. Bryan. Take them in the order that I have them in my stack. The first one I have is a motion to prohibit any further conduct that may intimidate or influence jurors or otherwise interfere with a fair trial. It was filed today. Mr. Goff.
Your Honor, the motion sets forth the legal authorities and the factual basis for the motion in greater detail and specificity than was brought to the court's attention earlier this week. Looking back over the case, it seems that during jury selection, not as many matters were brought to the court's attention as I had assumed, but those have now been brought to the court's attention by way of the exhibits attached to the motion. Your Honor, we are concerned about individuals consciously or unconsciously using the public gallery of the courtroom to influence jurors in this case, whether that's influence them, intimidate them, whatever. We've had instances during the jury selection process of nonverbal communications back and forth between the victim's family and one or more jurors. We've had several instances of outbursts in the courtroom. We've had notable people in the courtroom who have no apparent connection to the victim's family in this case. We do have a jury assembly room which seats ample numbers of people. I think the Supreme Court precedent makes, although it's technically an open question, all of the justices that have commented on it have either outright rejected the idea that individual members of the public have First Amendment rights in the public gallery, or suggested that it is intuitively not obvious that they have such rights. If the Arbery family has a minister or ministers that are their pastors or members of their church or otherwise, that's one thing. But just trotting in pastor after pastor after pastor, including pastors from other parts of the country that they have no apparent ministerial relationship with, is inappropriate here. And there's no reason, given the high-profile nature of this case and all the other unusual activities, protest marches and other things, there's just no reason to take that risk. We also have asked the court previously, and renewed that by written motion, is to identify the individuals who are sitting in the public gallery during the proceedings in this case. Otherwise, Your Honor, we, and I speak for Mr. Bryan, and whether co-counsel feel constrained to join in or not, that's for them to decide. But from Mr. Bryan's perspective, we're trying to make a record here. I'm not trying to be difficult or make anyone uncomfortable, but we can't have a record take up on appeal with respect to the impact of what's going on in the gallery without having that documentation. And I think the case law, although it is a relatively, the body of case law in this area is limited, but from what's there, I think the case law also seems to indicate that the court can't simply wait until something happens. We can't wait for disaster to strike. That the court has a duty, to the extent it can do so, to head off issues with the public gallery before they create prejudice to the clients, before they necessitate a mistrial. And we're simply asking the court to be more proactive. My understanding, and it's referenced in the exhibit, I think it's the first exhibit from the Community First Planning Commission, I think that's what it is. They have a huge rally planned for Thursday. Hundreds of pastors from across the country are going to be here for that. That is not something that is in response to anything that took place in this courthouse or during this trial. It is clear from the website of the organization, which has stated in more than once that my client, along with others in this case, are quote-unquote murderers, and they seek justice for Ahmaud, for Mr. Arbery. They have exceeded the capacity, the pastors who belong to that group, and I have not identified them. There's 21 apparently, black pastors in the community. They have gone, in that Facebook page and their website, they've gone beyond merely ministering to members of their flocks, whether consciously or unconsciously. And I think that conduct is such, in conjunction with the conduct of counsel, civil counsel for the Arbery family, Mr. Merritt and Mr. Crump, and in conjunction with the Transformative Justice Coalition and all these other groups, when you look at the big picture, I think that we are rightly concerned about the ability of Mr. Bryan to receive a fair trial if we keep bringing people in this courtroom for who have no other apparent purpose other than by their mere presence to attempt to influence the jury in the case. Your Honor, the exhibits, I think, clarify, maybe in ways that weren't as clear during the jury selection process, how all these different groups connect together and what their purposes are. Several of these groups are created specifically as a result of the death of Mr. Arbery. So again, we're asking the court to allow us to have a record that we can take up on appeal, and ask the court to take proactive measures to ensure that the presence of people in the gallery isn't violating the rights of our clients. I am told, I do not know whether that's true, that some of the pastors are packing in the sense that they are bringing their lawyers with them. And apparently, I'm told, of course, you know what rumor and speculation and gossip are like in a small town, that there'll be motions coming to be filed with the court in advance of their appearance. But that doesn't change our position, which as Mr. Bryan's right to a fair trial is paramount. And since there are no First Amendment rights to have content in the public gallery, then there's no First Amendment consideration there weighing against it. It's not an issue of public right access to the courts or the court proceedings, because they're on national TV and they're unavailable on a big screen in the jury assembly room. And although this court has labeled me reprehensible, or
you reprehensible. Let's be clear about that. It was not specific. I was talking about some comments that were made. So I checked to make sure, because I want to make sure that I did not direct that at you personally. Those comments were the reason I felt that at that time I needed to address where the court was on things. So I just want to make sure that's clear.
It is, and to be fair, like I said last night, looking back over it, I don't think the Community First Planning Commission, that group of pastors, I don't know that we specifically addressed that with any of the jurors during jury selection. So maybe I assumed too much. I will say, judging by my phone being blown up in my emails, that certainly the general public has interpreted the words of the court in a different manner than perhaps you and I did.
Well, just to be clear, I've said over and over again to all counsel here that personal attacks are not an appropriate, the court is not an appropriate place for personal attacks. You can comment on what's happening in the court, but do not direct it at anyone personally. So that's why I wanted to make sure it was clear that was not a personal attack on the court's behalf.
Thank you, Your Honor. From my perspective, though, I suspect I'll be getting, continuing to get love letters and messages for days to come. But be that as it may, Your Honor, we are asking the court to take stronger steps to ensure the right of the defendants to a fair trial in advance of the events planned for this Thursday.
We join, Your Honor.
If I understand the motion, it is the remedy that's asked for is for the court to take note on the record in some way of who is in the gallery every day. If that is what this motion is, I don't see any harm in that, especially given the potential harm, as Mr. Sheffield said yesterday, the 2 strikes we've already had. Other than that, I don't adopt, other than that remedy that's being sought here.
Anything from the state?
No, Your Honor.
All right, the motion that is before the court, the written motion, has been addressed by the court on at least 2 occasions, and the court's indicated its position. I'm not going to replow that ground. The court's position on the record, when the motions are made verbally, remains the position of the court. I understand that this was to document the record to make sure that the court had the legal authority that was being relied upon, as well as some of the additional information here from the defendant. So, to the extent this is a renewed motion, a motion for reconsideration, or otherwise, the court's rulings on the record.
Thank you.
I have a second plea in bar, speedy trial violation, and motion for reconsideration.